Good afternoon, everybody. My name is John Giardinelli. I am of counsel with the law firm of Tyler and Bursch, and I'm privileged to be here today with one of the partners of Tyler Bursch, Todd Frahm. We're going to talk about 5 laws that just went into effect on January 1st. Todd, why don't you start us off with the new independent contractor law?
Sure thing. Yeah, and happy 2021 to everyone. As you know, since it's a new year, we now are going to have no problems going forward. So anyway, just wanted to go, start off with Assembly Bill 2257. As most of you know, the courts came out with a case, the Dynamex case, that changed all of the way that they classified independent contractors. That case was later basically put into a statute that said how this whole thing is going to be done, and that required the ABC test, which was very convoluted, very strict. AB 2257 has changed that in certain areas, not the least of which is going to be how appraisers are handled. Appraisers now will not be subject to the Dynamex ABC test, but instead would be subject to the much more lenient Borello test, which was really the old test that we had, or whether you're controlling the way that they do their work and those type of factors. So that's going to be a pretty big change going forward.
Yeah, especially with the passage of Proposition 22, which eliminated Uber drivers and Lyft drivers and others from the law, considering that the law was passed initially, AB 5, to deal with Uber drivers and Lyft drivers. So that'll be kind of fun to watch, how that gets forced. Well, I'm going to talk about Assembly Bill 3182. As we all know, California is having a tremendous problem with a housing shortage. I'm going to argue about why that is all day long, but we need housing. And so one of the things that property owners associations, HOAs, have been doing is limiting the number of people that can use their property for rentals as opposed to primary residence. And under 3182, an HOA cannot create a limitation that exceeds 25%. So if you're in a homeowners association and less than 25% of the people are renting, then there are people that can still elect to rent their properties. The caveat is it's got to be for at least 30 days or longer. They still limit the ability to rent housing on what's called a short-term basis, less than 30 days, things like Airbnbs and stuff like that. So long as the governing documents clearly allow the association to have that restriction, those restrictions are still a good law. This also applies to associations that may want to limit what's commonly referred to as ADUs, or accessory dwelling units. So if I have a garage and I want to convert it into an apartment, under the limitations of this law, and of course nothing replaces actually reading the statute and reading what is required, there are ways of creating an ADU and or a JADU, which is a junior accessory development unit, that will comply, and this, regardless of what the CC&Rs or the bylaws say, not a thing the association can do about it. So those new laws have gone into effect, and of course associations all over the state are trying to deal with those as well.
Yeah, it's going to be a lot to deal with. I mean, obviously you're going to, if you have, your mother-in-law's quarters has now a family living in it, HOAs are going to be dealing with parking issues and all kinds of other things that are going to be.
Not to mention the aesthetics. I mean, the fact is, I move into a unit thinking that this is the way everybody's going to have their properties, and suddenly the next door neighbors decided to create a rental, and I can't do a thing about it under those circumstances.
Going to be interesting.
Yes, it is.
So the next one is Assembly Bill 685. This is a COVID-related bill that basically requires that employers are required to give notice to all employees who have been on premises with within the infectious period with a person who has COVID. It's going to require notice basically in the standard way that you would be giving notice. And again, it's within 1 day of knowing about it. This is, I think, going to become like huge. I mean, because Assembly Bill 1159 already put in a rebuttable presumption against an employer that if you get COVID and somebody had COVID at the workplace, it's a rebuttable presumption that you got COVID at your place of work. So now if you're doing this and you miss it, you don't do it within the 1 day, and there's this rebuttable presumption, I mean, it's a lot of possible liability for employers.
And there was a bill that was introduced that would make it an irrebuttable presumption.
Mm-hmm.
So the impact it's going to have on employers and their workers' compensation premiums probably going to be pretty astronomical as we go through time. Well, another bill that one thing I did want to mention, Todd, that and Quinn, it's not related to this, but just to show you the extent of how complicated this is going to be, and even lawyers are still trying to sort through this. Is I read a great article the other day about mandatory vaccinations and how are employers going to be dealing with mandatory vaccinations and all those legal issues. So maybe the next time we get together, and I can come out of my cubby hole and join yours, we can talk about that issue, because I think that's going to become a hot button topic down the road.
Agreed.
So I'm going to talk about AB 3088. That's not a new law technically. It was passed back in August of last year, went into effect. A couple of things about it though, because they've made some changes to it already, and those changes have to do with mortgage service providers and the requirement that they take certain steps to make sure that in certain kinds of loans you can get forbearance from a lender. It also deals with certain COVID-19 restrictions. So if you've got a loan, particularly if it's FHA, but even a conventional California type loan, and you've got some problems paying your mortgage because of COVID-related issues, maybe the tenant's not paying rent, something like that, then you might want to take a look at that law, because there are now mandatory provisions dealing with forbearance. I talked to a fellow the other day who's a lobbyist for one of the large trade organizations, and apparently 3088, which is the bill, its primary purpose was to say you cannot evict a tenant who became delinquent in rent because of a COVID-related issue, which is a very broad definition, between March of last year and actually January 31st of this year, under a lot of different circumstances. The law, very complicated 36-page law, but it basically says if I'm delinquent in my rent, you cannot evict me for that, which is the lion's share of evictions, frankly. So that means I can't do that anymore. That means the landlord's got to figure out how to pay their mortgage. That law is set to expire on March 1st. There are bills now pending that will extend that to an indefinite period of time. So landlords are going to still be dealing with these issues, not next year, because we're in next year now, but be dealing with these for quite a long time. And what they're going to have to do is to sue a tenant in small claims or some other way, and then hope for the best in terms of collecting on their judgment, but they're not going to be able to evict.
Yeah, and the issues with the small claims court, I mean, obviously, and people have asked me that question as well. Well, they said, well, small claims court limitation is $10,000. Right. It's not limited under 3088. No. You can go after the full amount of the rent. But if you've got somebody who's, let's say they've actually had a real hardship, which some people have. A lot of people are using this just as a means of not paying their rent right now. But let's assume you've got somebody that has had a hardship. You get a small claims judgment against them for the past due rent. You can still never evict them for the non-payment of that, even if they fail to pay the judgment. And the likelihood that you're going to collect a money judgment after that point, slim to none.
I know you do some bankruptcy work, isn't it correct? That let's say you get a judgment against me for, and by the way, the $10,000 limitation goes up to an indefinite amount. I believe it's on March 1st of 2021. So let's say you haven't paid me since March 1st, and you haven't paid me any portion of the rent that you owe me, and you claim it's for COVID. You sign the declaration, and I get and the rent's $2,000 a month. Well, that's a pretty sizable chunk. That's $20,000. Right. So I get a judgment against you for the $20,000, and you file bankruptcy, right? I still can't kick you out of the house, right? And if they extend this bill past and I said March 1st, actually February 1st. If I extend this bill, if this bill is extended past February 1st, there's a good chance I'm going to lose that house to the bank, unless I can fall under one of these forbearance. But I still owe the money to the bank.
Right.
And if I'm using that money to live on, I'm in pretty bad shape.
No, it's not a good situation at all for landlords and what's going on in the state currently. Everything that's been coming out is clearly based on this. California's kind of, for quite a while, has had a bent towards pro-tenant, pro-consumer.
Pro-employer.
Yeah, pro-employer. So what we're getting over and over again, I mean, it's these type of things. Assembly Bill 2463 is another one of those. I mean, that prevents, let's say that, we've got a situation where I become delinquent to you and you get a judgment lien against me and you want to put a lien on my home. You put the lien on my home, I still don't pay. Well, in a normal world, he could foreclose the lien and get paid, and it would incentivize me to pay before that happens.
Not anymore.
2463 takes that away. So again, there can be no foreclosures of a judgment lien if it was based on a consumer debt.
Right.
So you can put the lien on the house. You could get paid when that house sells.
If it sells.
But you can't foreclose it.
Right. And if the lien that's in front of you, it doesn't prevent you from being able to have any equity in the house based
Right.
on your mortgage or based on your collection. So yeah, it's a tough time. Again, I understand a lot of these laws. I mean, nobody wants to see homeless people. That's why you have restrictions on evictions. But when the government steps in and chooses sides, and you end up with all of the burden for all of these issues falling on certain groups, employers or landlords, not all of whom are rich. 47% of all homes are owned by mom and pops, rental houses. Or you're talking about picking and choosing sides. Some people are in pretty bad shape, and maybe that explains why lots of people are looking elsewhere to invest their money.
That's true.
And what impact will that have long term on the state of California? So a lot of stuff going on.
There is.
And I was told the other day that there's going to be about 5,000 new laws being considered in this next session.
Well, we've got a legislature that needs to find something to do with their time.
Good for you and me, because we're lawyers.
There you go. That's for sure.
Yeah.
That's for sure.
All right.
But I mean, a lot of this stuff is very confusing. It's confusing, like John said. I mean, lawyers are still trying to wrap their heads around a lot of this stuff, waiting on the courts to decide how this is going to be interpreted. If you're running into any problems with any of these things, we would be happy to help you out. Give us a call here at Tyler and Bursch, 951-600-2733, or go to tylerbursch.com. And I look forward to talking with you soon.